Welcome to the U.S. Patent and Trademark Office's USPTO Hour. We are thrilled to have you join us. Today is February 4th, and our topic is the protection of one's name, image, and likeness, or NIL. We hope that today's topic will spark curiosity, encourage conversation, and answer questions that you may have on the topic. Today's program will be recorded and posted to the USPTO's USPTO Hour webpage in case you'd like to hear it again, or you're unable to stay for the entirety of the program. We are extremely fortunate to have our very own MVP, John Squires, the Undersecretary of Commerce for Intellectual Property and the 60th Director of the U.S. Patent and Trademark Office, introducing today's program. Director Squires has a long and successful history working in the exciting field of intellectual property. Prior to joining the USPTO, Director Squires was a partner and chair of the IP Emerging Companies practice at Dilworth-Paxson. He was also an adjunct law professor at the University of Pennsylvania, Carey School of Law. He is recognized as one of the world's leading attorneys in AI, blockchain, fintech, cybersecurity, and risk. He has deep hands-on experience in patent licensing and patent monetization. He has launched and sat on the board of a number of IP risk-related companies and organizations, including the Risk Assistance Network and Exchange, Finclusive, and Regulatory Data Corp. He was the chief IP counsel at Goldman Sachs, where he founded the investment bank's extensive IP practice. He has amazing skill sets in data privacy, digital currency, cryptocurrency, regulations, startups, patent portfolio analysis, and the list goes on. He is also well-grounded in the sciences. He holds a BS degree in chemistry from Bucknell University and a law degree from the University of Pittsburgh School of Law. The United States and we at the U.S. Patent and Trademark Office are fortunate to have someone with such a deep understanding of IP and new technologies serving in such an important position at such a critical time. Director Squires, the floor is yours.
Thank you, Elizabeth, for such a wonderful introduction. Good afternoon, everyone, and welcome to America's Innovation Agency. Thank you all for joining us. I'm excited to kick off today's USPTO Hour, and we're so delighted to have you join. For those new to our regular webinar series, including me, the USPTO Hour is a discussion forum directed to a broad range of intellectual property topics, the vibrant developments and issues of the day, all at the intersection of the agency's work and mission, and most importantly, the marketplace and our shareholders. We always feature our very own USPTO subject matter experts, the best in the world at what they do, as well as special guests like we have today. An absolute luminary in his field, Professor John Fitzgerald Duffy of the University of Virginia School of Law. And importantly, you'll also get to ask the questions that are on your mind, the hard questions. What do we need to hear? So let me begin with telling you how amped I am for today's program. It includes two things that really get me going, as my USPTO colleagues can tell you: intellectual property and sports. Today, at America's Innovation Agency, we're going to turn to our trademarks business unit, or America's Branding Agency, as I like to say, and the fascinating issue that is the shifting sands in the world of name, image, and likeness, otherwise referenced as NIL, and specifically how collegiate athletes, sports figures, entertainment stars, influencers, and others are using intellectual property to protect their publicity rights, their internet presence, their name, image, and likeness. The sports arena is leading the way, and wow, what a time. This year's World IP Day theme is, you guessed it, IP and sports. And we have America's 250th year. It's an Olympic year for Team USA, with opening ceremonies just days away, and of course, the big game this weekend. Choose your metaphor, but this is where the puck is going, where we need to have court vision, and with the urgency of now, it's time for us, America's Branding Agency, to dive right in. All puns intended. Oh, and just when you thought you could see the whole field, add in the tidal wave of AI. And those of you who have heard me speak on AI know how I explain it. AI is the Roy Kent of breakthrough technologies. It's here, it's there, it's every you-know-what where, to flip the script, as it were. Having just returned from a keynote at the LA IPLA's Washington in the West event, where else? In LA. For both our stakeholders and this office, this topic is top of the batting order right now, more than ever. As AI expands and the threat of AI impersonation in cyberspace becomes more and more prevalent. Now, rest assured, we are here to help, and we are here to meet the moment, to help you protect yourself and name, image, and likeness. We're with you in the eye of the AI hurricane that shows no signs of letting up. So what better time than on the doorstep of Super Bowl 60 this weekend for America's branding agency to help you pregame as we watch two quarterbacks who sit at the center of that story. New England Patriots will be led by second-year quarterback Drake May, the former North Carolina star, whose rapid rise has him in the Super Bowl in just his second NFL season. Across the field, we have Seattle Seahawks starting Sam Darnold, a former USC standout, and, hard to believe, the Trojans' first quarterback to start a Super Bowl. Fight on. Both these quarterbacks built enormous brand value in college long before NIL collectives and revenue sharing took hold. Darnold, for example, threw for over 7,200 yards and 57 passing touchdowns while at USC, generating massive exposure, of course, for the Trojans. Both my son and daughter are proud USC Trojan alums and, in fact, attended the same time as Sammy D, lived in San Clemente for a time as well, his hometown, and in fact, I saw him at his first home start in the famed LA Coliseum. And right then and there, in front of 90,000 of my BFFs, I can tell you, he was a special player, had all the markings of a pro, and now here we are. Good luck, Sam. As to Drake May, likewise, he became the face of North Carolina football, lifted up the entire program, and now he's a projected franchise quarterback seemingly overnight. Good luck, Drake. Now, if both these QB1s were coming through college today, the law is now treating a big part of what they created, their names, their images, and their likenesses as a valuable property right, and a bundle of rights that can be licensed and monetized. NIL has brought the abstract doctrine into the heart of the college sports debate. The market for college athletes' NIL has grown rapidly into the billions. Collectives and schools are now routinely signing athletes to contracts that slice and package their identity rights, including what they can do with their name, photo, social media presence in connection with their brand. And this is where things get interesting in the school student-athlete dynamic. Indeed, we saw first a few weeks back a glimpse of this when Duke University took action against an action that was unthinkable 10 years ago, where the Blue Devils sued their own quarterback, Darian Mensah, over an NIL contract. Reportedly, the NIL Inc. deal promised Mensah millions of dollars over 2 years and gave Duke broad rights to his name, image, and likeness in connection with anything on the gridiron. But when Mensah entered the transfer portal to look at other colleges, Duke went to court, arguing his exclusive license belonged instead to the university. The case, of course, has since settled just last week. So going forward, how exactly do individuals ensure that their NIL rights remain just that, meaningfully and demonstrably theirs? And what control do they have in this new stick in the bundle of rights such that they are not inadvertently or otherwise signing away broad, long-term control, eroding their own freedom to use their identities? Beneath these legal issues is an unsettled landscape. And peeling back the layer of this legal onion, the core rights at stake are rights of publicity, which are creatures of state law and vary from jurisdiction to jurisdiction. And now, enter Sandman, well, enter Mr. Matthew McConaughey. So as you may have seen, Matthew McConaughey and his legal team have decided that the best defense is a good offense, and his company has proactively registered with us the marks, including his iconic phrase, all right, from the movie Dazed and Confused. Along with these sound marks, he also registered 2 motion marks, which may help combat the increasingly risk posed by deep fakes. His registrations aim to provide effectively a force field against AI usurpation. And our agency, at the federal level, is playing an increasingly important role in protecting rights of these individuals and businesses alike. So what's at stake? The questions are causing a reset about how we think about and what we think about and how we use intellectual property. For example, how does one, and moreover, who can protect their name, image, and likeness? How can we at America's Brand Agency help you do that? Well, thankfully, Suiting up and taking the field with us today is one of our nation's foremost legal scholars and academicians at the leading edge of this fascinating development, Professor John Duffy. And John was also an outstanding student athlete in his own right on the storied Harvard track team, and indeed, years later, I believe, came in 7th. Was it 7, John? I believe 7th in the Marine Corps Marathon. I myself ran both the New York and New Jersey marathons, and let's just say they had me enter into the Clydesdale division. So, John, that's amazing. John is the Samuel H. McCoy Professor of Law and Director of Center on Intellectual Property Law at the esteemed University of Virginia School of Law in Charlottesville, Virginia. John was also appointed to the USPTO's Patent Public Advisory Committee last year by Commerce Secretary Lutnick. And when it comes to the most impactful scholars or practitioners in both the worlds of administrative law and intellectual property, John is beyond question the GOAT. John changed the law of obviousness in the famous KSR case, where he virtually single-handedly carried the issue over the goal line. John identified a constitutional flaw in the appointment of APJs in what he calls the little paper that could, and was featured in the New York Times with this, and then helped Congress fix the problem. I've had both the personal and professional honor of working with John when I was at Goldman Sachs and chaired the Securities Industry and Financial Markets Association, and co-authoring an amicus brief, Zimbilski, on patent eligibility. Interestingly, when Ray Chen, now at the Fed Circuit, of course, was then USPTO solicitor. And we got invited to argue alongside the parties at the on-bank Fed Circuit hearing, and then ultimately carried the day at the Supreme Court. And John is leading the way with his thoughtful scholarship now in NIL. If there is a frontier of IP and a legal issue to be found, you can be sure John will be there to help us make sense out of it. As I said, the GOAT. Thank you, John, for taking the time to be with us today and engaging in this discussion. So for those of you joining us, today's your chance. I encourage you to get in the game and bring it on your name, image, and likeness questions. Welcome, everyone. I now hand the baton back to Elizabeth Doherty. Elizabeth, first and 10.
Thank you, Director Squires, and game on. Welcome, Professor Duffy. I am really looking forward to our conversation today, and I think I can say that on behalf of all of our audience.
Thank you.
Well, I'm sure some of our listeners and attendees may be familiar with this topic. I suspect that for some, it might also be a first introduction.
Yes, I think it is an extremely important field that both has old roots but is also quite new. Its old roots include doctrines of publicity rights and unfair competition, much like trademark law originally came out of older doctrines and has grown up in the last 2 centuries, especially at the federal level, from really nothing into a very substantial part of this large agency that we are sitting in. Name, image, and likeness is something that has developed out of publicity rights, but I think it is more than that now. It is becoming more than that. And it's of special importance to this agency, as you can already see that people are trademarking not just their name or their stage name, but their likeness, their image, motions. The director mentioned Matthew McConaughey, who now has a trademark on certain motions. I don't know them, but if I did know them, I couldn't do them here online, I suppose. But those are new developments that are bridging this older area of publicity rights with traditional trademark law. And one of the most interesting things is there's no real legal barrier to stop or to say that this can't be done. So it's up to the creativity of lawyers and their clients to think this is something I need. And this agency, I think, if you read through the statutes, is largely open to them getting rights in their name, their image, and their likenesses.
So what I'm hearing is that it's not, in fact, an entirely new area of the law, but what is it that has really brought this to the forefront? What has made it this now hot topic of conversation?
So that's of great theoretical interest to me as a scholar. One of the things that scholars in intellectual property law and property law in general think a lot about is why do property rights emerge and become useful to society? And there is a very old theory on this that's sort of a foundational part of law and economics that says societies develop property rights when the costs of those rights, which are substantial, begin to be exceeded by, or the benefits begin to exceed those substantial costs. And the oldest paper in this, the sort of foundational paper, was written by an economist from UCLA named Demsetz. It's now called the Demsetzian theory, that suggests this does happen. He used as an example the development of property rights in an indigenous tribe in the Labrador Peninsula, now in what's now Canada. One of the problems with that is, while that might be a good example, it's very old. The evidence is extremely fragmentary as to exactly what happens. The relevant tribe who was developing property rights had no written language, so there's no records directly from the parties who supposedly were developing these rights. But at least his theory provides a framework to sort of explore why things are happening. I think that framework is applicable in our current matter as a framework. First, we'd say the costs of giving everybody rights to name, image, and likeness is not insubstantial. You're giving new rights to everybody, perhaps everybody in the country, but it's not a huge burden. There's definitely cost there. The value, I think, is becoming much greater as people really begin to take pride and ownership in their own personal brands. We're seeing this on social media most prominently. We see it in athletes. And we see that also the value of that is becoming greater because people are demanding these rights. They see deep fakes and images their own image being exploited by artificial intelligence. And there is a sense that economists just have to take for granted that they really find this distasteful. And an economist doesn't usually talk about why costs are costs. I mean, if somebody wants to pay millions of dollars for a piece of canvas with paint on it, the economist just says, well, people value that. Well, people have a certain value that they don't want to see their name, their image, and their likeness exploited for reasons that they do not agree to, or especially exploited in ways that are quite abusive. And we can talk about that later. Congress has even just less than a year ago passed new legislation by a nearly unanimous vote that is trying to address the artificial intelligence problem. And obviously there's the sports angle. In the United States, only name, image, and likeness in the NCAA began to allow college athletes to exploit name, image, and likeness. And that was a huge increase in interest in that. But you can't just explain it with American sports because it's happening across the world. So I think the emergence of AI, plus just the general sense that people are taking pride in their own names, their images, their brands, that's happening worldwide with the older technology of social media and the newer technology of AI is causing the value of these rights to rise to the point where societies, not just this country, but other countries across the world, are seeing fit to extend different and newer property rights to this field.
It's just fascinating. Would you suggest that those who are most affected or most open to this opportunity of protecting their name, image, and likeness, is it limited to the best of the best, our sports athletes, our entertainers, our social media influencers, or should you and I be working to protect our name, image, and likeness? Is this something we should all be cognizant of in approaching cautiously?
Well, I think about a half century ago, Andy Warhol said, in the future, everybody's going to be famous for 15 minutes. And I think we're in the future, actually, where we all have our own brands that we care about, and that we would be very upset if we see artificial intelligence inserting our image into a video that might be, completely inappropriate video that we just do not agree with. So I think that Warhol was right. There's the change that's occurring, I think, is a democratization of what used to be publicity rights. And one of the reasons why I think we should change the name, I think it's already being changed. And people who are trademark lawyers, if you say like, what's in a name? Well, I don't have to convince your trademark lawyers that there's a lot in a name. So I think if you say publicity rights, people do think, oh, well, that's, Taylor Swift and Elvis Presley and lots of people out there, but not me. But if you say name, image, and likeness, it tells people, yes, it's you too. And you should think about your name, your personal brand, about the things you want to do in your profession, in your field. And that means a lot more people. That just doesn't mean a few thousand people who are associated with professional sports or college sports or Hollywood. It means a much larger set of people who have a reputation and have an image and name in their profession and their jobs. And they should think about how they are protecting that and be careful about it.
Is there also an aspect to the conversation here with regards to minors?
Yes, so one of the things that I mentioned is that there was new legislation that I think does not grant property rights. And so I think if I were going to critique this new legislation that was passed in 2025 and signed into law last spring, I would say it may be doing some good, but it's not using property rights. But the congressional record to get this legislation passed involved minors whose images were being harvested from school yearbooks or from other sources that are available, or maybe even from pictures from their friends and family that got put up on Facebook or some other social media site, and then got inserted via AI into the most outrageous videos that are completely inappropriate for minors. And this caused an enormous amount of pain to many parents and minors themselves. So Congress passed a statute called the Take It Down Act, and it includes various administrative and criminal penalties for misappropriating somebody's image. It did not, it seems to me on my reading, did not grant a new property right. And I think there's value in property rights. Property rights can be enforced by individuals. If there are just administrative rights or criminal rights, you have to go to the government and convince somebody in the government that this is worth their time. If it's a property right, you can go to court yourself. It's a civil right. And I think that is something that we should, that the Congress might even think about adding. But the minors themselves and individuals can come to this office and get rights, as some famous people have done. They are, I think, not super expensive to get, and that is a property right. And so I think that this is one area where trademark law and image law could perhaps really do some good.
We've touched on a number of areas of the law that seem to circle the topic or impact the topic. Can you run through what that list looks like? Trademark law, rights of publicity, rights of privacy, state laws, even Congress passing a law. What do you think is kind of the playing field right now of NIL rights and their protections?
I think it's very complex. You just listed, I think, half a dozen candidates for laws that are interesting. Many states have what's called common law protections. For those of, I suspect there's a lot of lawyers here, they know what that means, but for people who might be athletes, that's judge-made law in states about rights that you might have, and they might call it publicity rights, they might call it privacy rights. There's also statutes in many states. California has a lot of statutory activity in this area for obvious reasons, because they're historically the people who are most interested in this are actors and entertainers. Although Tennessee also has activity in this area. I think one of their most famous statutes is called the Elvis Act. I don't know why they chose those letters, but that's an acronym for a statute in Tennessee. These statutes and rights have been expanding over the last century or so, really starting from almost nothing to continue to be expanding today. So questions about whether they survive death is a huge issue, and states are, I think, incrementally pushing those rights into something that can be a property right that can survive death, that can be inherited, and can be protected by the estates of parties. So that's a set of rights. In terms of federal law, I think the bullseye right now is the trademark office, which we're sitting in the first floor of. So that is what is the federal law. I think the advantages of trademark is it is federal, and it is clearly an intellectual property right that's federal, and that has advantages, especially with respect to other federal laws. Makes it clear that certain statutes that protect intellectual property laws rather strongly do apply to trademarks. So I think that's something that sophisticated people are saying, well, the state law, there's some holes and there's some non-uniformity, but the federal trademark law is a well-tested vehicle for protecting property rights, and maybe that's something I can use to protect property rights and protect all of these aspects of my personal brand. People call it a personal brand, and I think that used to be a metaphor. Personal brand, they didn't really mean it, but they now do. Some people do mean it because they have trademarked it. It is a brand.
It occurs to me with this level of complexity, if we had an audience member today who's sitting back and thinking, I need to protect my personal brand, who are the experts out there? Who are the professionals that they should be seeking to help them in this activity? Certainly it sounds like a trademark attorney would be a good first step. Are there other places they should investigate assistance?
I think entertainment and sports lawyers do increasingly think that their expertise absolutely has to be in this area, that they not just think about trademark law or contract law, that they have to think about this field of intellectual property law. They absolutely have to. I teach my students that name, image, and likeness is still a pretty wide open field. So if some young lawyers-to-be or lawyers are on watching this show, I think you ask who's got the expertise, and I think the answer is even the people in this field are gaining expertise. They're still learning. They're still developing out this new set of property rights, and the tensions and interaction between state law and federal law are definitely being worked out. There's significant scholarship on that already. I think this is one of the most interesting things about studying a property law that's emerging. The Demsetzian old thing dealing with property rights that may or may not have occurred in the Labrador Peninsula 400 years ago, when we have fragmentary records and no written language from the people involved, just radically different than today. Today, we can see the building out of the property rights. And one of the things that I think happens is societies across the globe are building expertise and trying to figure out not only how to create the right, but how to optimize it and how it fits in with other pre-existing pieces of property rights and other rights that are out there. So I think this is an area that is, I hate to say wide open, because you might think like somebody's going to call me and say, oh, I do this all the time. But I think that's, if they do it all the time, they're finding increasing competition with them. One of the stories over the summer that I read about, which I think is very interesting, was UNC, which is an ACC school, a rival to the University of Virginia, was hiring people who are consultants about name, image, and likeness and branding. And so those are some of the people. Obviously, UNC had found a group that is trying to specialize in that. You could tell it was a relatively new group, so they're building out their expertise, and their focus was to get the consultants to give advice to their athletes. So the whole set of athletes, not just the football and basketball players, but the entire set of athletes, to think about their brand and think about how they're going to manage their brand, both while they're in college and perhaps outside of college. So that was in the New York Times because it was news. It was absolutely news. And universities are thinking about this because if you ask somebody in the athletics department, is this kind of new, or is this like, you could have gone back to the 1980s and everybody said, oh, same thing, same old, same old. They would say it's absolutely new. It's the last 10 years or so. We're still trying to catch up. University of Virginia is putting efforts into this. I hope that our law school can help support their efforts in this. And if there's future college athletes out there, UVA is a terrific place to go to school. We're cutting edge, beautiful campus, currently under some snow, but it's a great place to go to school.
Way to make that pitch and plug.
I've got actually, if you're talking about
less.
branding, my tie is the University of Virginia colors.
Indeed.
So I am literally trying to fly the flag of the University of Virginia. How many times can I say that before you stop me?
Well done. Well done, sir.
Yes.
You know, it's exciting to hear how this frontier is still being written. It's still being shaped, and the opportunity for not only our young scholars, our young athletes, but even our professionals to continue to shift and grow as we define the parameters of what this area of the law is going to continue to look like.
I absolutely agree. And I think this is true for intellectual property generally. I start off my patent class, which is an area I've devoted a lot of time to. It's how I got to know your director here, John Squires, by emphasizing how young the field is. And I think we have this incorrect image sometimes that law is very static and law changes very slowly. And in some fields that might be true. In, for example, tort law, the law of accidents, you can talk about what the Romans did. And even the book I teach out of talks about Roman law and about their approach to very similar situations. Intellectual property law is wildly new. The patent system is maybe a half a millennium old. And you might think, well, that's a long time. That's for young 20-somethings who I'm teaching, they think 500 years, that's old. But really, it's only been the past 200 years that it's had huge economic effects, and it is changing itself. I've helped have some of the changes in that. New legislation has occurred, not just in this country, but in other countries. Within our lifetimes, the last 20, 30 years, we've seen enormous changes. And I tell my students, you will see changes. NIL and trademark and publicity rights, whatever you want to call it, I want to call it NIL, by the way, to make it clear. That is very new, and we are seeing enormous changes. Things that are happening just in 2025 and this year. The director mentioned the trademarking of gestures and other things. Super interesting development. There's been litigation. There's this lawsuit between Duke and their quarterback. Very interesting. And of great interest to UVA too, since UVA and Duke have a substantial football rivalry as well. But it's super interesting for a variety of reasons. It is new. It's the development of a new property right. I think we can examine it under a microscope rather than look back 400 years to some fragmentary records that we're not sure of. Look at this under a microscope and see how a new field of property has emerged from other predecessors.
Professor Duffy, are there any concrete steps, so to speak, or words of wisdom that you'd like to present to our audience today as to steps they should be taking as individuals as they begin to not only think about it, but actually begin to protect their name, image, and likeness? Should they be documenting? Should they first reach out to a professional? What should they be thinking of, particularly in light of our conversation today?
So I do think that the trademark system is one of the things that they should absolutely think about, because it provides a solid federal intellectual property protection that they can talk about. They can point to a document that is signed by the director that will confirm their property rights. The property rights that exist under state law, they probably will get without any filing or any fees associated with it. So those will emerge naturally. They can talk to a lawyer if they begin to think somebody's exploiting my rights without my permission. They would get those rights as a matter of common law without any filings or things like that. But I think it is, if you're going to ask of something that they can do that's proactive, I think the trademark avenue is increasingly attractive because of its federal nature, because there's worldwide treaties about intellectual property, including the trademark system. So it provides a platform not only to cover the United States, but also to potentially cover the world as well. And you might think, like I talked about the democracy, the democratic aspect of it, but that occurs over the world too. Influencers today who are on Instagram or something like that, they're not just looking at the United States. They're often looking at a very specific audience that might be worldwide. And so I think that worldwide audience is an important part of what they're doing, and they should think about trademark. In the field I used to compete in, which is road racing and running and distance running and things like that, the market is not just the United States. It's not like American football where many fans are in the United States. The market is worldwide. And there are many countries that are very active in the field. And so the audience for even somebody who's an athlete in the United States might include many, many people in Europe, many, many people in Africa, Asia, and other things. So they might think about the desire to have a worldwide brand.
It's just fascinating. I've got one last question for you before we not let you go, but turn to the next portion of our program today, and that is we've spoken directly to our audience as people who may be protecting their brand. Would you also have any words of recommendation or advice for the USPTO or for Congress or the states as they look to continue to develop and protect this area of the law?
So for the USPTO, I think you should be open to and ready for, I think, an increasing wave of filings seeking trademark protection that are basically directed to name, image, and likeness. I think college athletes are going to get the message. I think one of the things you should be doing, we're doing right now, which is getting the message out that this agency is not hostile to this development, is willing to help, and there are other things. With respect to Congress passed legislation dealing with these deep fakes, which is a terrible problem and I think was causing significant harm to minors and others. I think that they should take seriously the idea of a property right regime and perhaps consider how that property right regime should be structured and how it will also interface with the trademark system, whether it will be under the, which agency it will be in. I think, the USPTO and the Commerce Department are natural fits. I know the director of the USPTO has two titles. It's not just the director of the U.S. Patent and Trademark Office, but it is also the Undersecretary for Commerce for Intellectual Property. So I think it sort of naturally fits within this department and this agency. But I think sometimes Congress thinks as a first attack, as it did this past year, let's criminalize. This is awful behavior. Let's criminalize it. And oftentimes civil law and civil individual rights can be more effective than throwing people in jail. Throwing people in jail and prison is very socially costly. It should be not your first instinct, it should be your last instinct as a society to throw a bunch of people in jail, particularly in the minors aspects. A lot of the people, it seems to be, who are doing these minor deepfakes of other minors, they were minors themselves. And so throwing a lot of children in jail doesn't sound like the number one thing to do in terms of protection of individual rights. Granting property rights and making it clear that you own your image, you have rights to that, and everybody has to respect that. I think that that's a better way to do things. Internationally, the USPTO has an international mandate. Other countries are very much thinking about this. Denmark, another article from the New York Times, another thing that you could look at, many papers, was Denmark is thinking about granting a copyright to every citizen in their name, image, and likeness. That's a different branch of intellectual property. I think that might not be the greatest way to go. But I think it's worthy of discussion. Other countries like India are also developing frameworks for this. I think an international discussion would be super interesting and should be on the agenda of U.S. trade representatives and also this agency, which has an international reach. So I think those are some of the suggestions I would have for governments.
Professor Duffy, thank you for being our guest today. Thank you for sharing your expertise, your thought. I'm going to have you sit tight because we do want to invite our audience to ask questions. But before doing so, I'm going to turn to my colleague, Liz Jackson, who is the acting director of the Northeast Regional Outreach Office. She is also a trademark expert. So Liz is going to lead us in a discussion on some trademark nuts and bolts and what you need to know. Liz?
All right. Thank you, Elizabeth. And thank you, Professor Duffy. That was wonderful. And you teed me up quite nicely when you said trademark law. Like, how can you do it? I'm going to take it back to basics about what a trademark is. And then we'll look at when NIL can function as a trademark. And then if you're convinced, I will give you some tips about how to apply for a trademark application or registration with our office. So what is a trademark? I feel pretty good that you guys have seen these marks on the screen right now. We've got Coca-Cola, Apple, McDonald's, Microsoft, and why these trademarks are so famous, and in fact what makes them trademarks, is that they all identify the source of particular goods or service. And that's what a trademark is. So for example, McDonald's identifies the source of a fast food restaurant. Coca-Cola identifies the source of goods, soft drinks. Apple identifies the source of computers, among other things. And this is very important because it allows consumers to find you and know your brand and keep coming back to you to buy your products or buy your services. I have a good friend. She's a Diet Coke person. I think we all know those people. And I can only imagine the first time she tried Diet Coke, it was magical. But how do we make sure when she wants that same drink again that she gets it? And it's the trademark Diet Coke that allows her to buy what she is expecting to buy and wanting to buy. So it's good for keeping your consumers coming back to you, and it's also good at protecting the goodwill that you've created in your brand. A trademark is also the legal protection for the brand. So if anyone is using your trademark on different goods or service, counterfeiting you, you have a legal recourse. Does this matter? Yes, this matters quite a lot because on your screen, this is how valuable trademarks can be. These are the most valuable trademarks. We've got Apple at number 1. I did check this yesterday, and it is Instagram and now McDonald's at 9 and 10 instead of Nike and BMW. But I think they're all doing pretty well. So very valuable trademarks. So what is a trademark? It can be a word like Nike. It can be a phrase like just do it. It can be a design like the swoosh or a combination. It can be a great many things as long as it identifies the source of goods and services. So that brings us to what is the difference between it and NIL. Like Professor Duffy explained, the name, image, likeness, that's your right, but it isn't a trademark and until it's used as the source of goods or services. So for example, you've got Michael Jordan here, that's his likeness, but then when that same likeness is put on a shoe, and it becomes the source of shoes, it's a trademark. And people start saying, you want those Air Jordans? I do, and that's when it becomes a trademark. Like Professor Duffy mentioned, you do not actually have to register your trademark with our office for it to be a trademark. The minute you start using your name, image, likeness as the source of goods or service, you will likely have common law trademark rights in your state. But if you want greater nationwide protection. If you want to use the circle R symbol, you've got to register with our office. This also will prevent other people from registering your mark as a trademark. We'll make sure of that. You'll have various legal presumptions of ownership. You'll have the ability to register with Customs and Border Patrol to make sure counterfeits aren't coming to the country. So it's a lot of benefits to registering your trademark with the United States Patent and Trademark Office. So if that sounds like something you would like to do, I want to give you some issues to consider. So first, what is your trademark going to be? It can be your name, Liz Jackson, me. It can be a nickname or a stage name for Liz J USA. My brother made that up. It didn't last. Or it could be a picture, likeness of yourself. I want to give one caveat. If your trademark is a picture of you and you're wearing a uniform with a team or a university on it or a mascot, be aware that it might be another person's trademark. You do not want another trademark in your trademark. So be wary of that. And what are the goods and services you will be using this on? And I think I've talked about this a lot, so I'm going to devote a whole nother slide to it and we'll come back to that more. Is the trademark you want too similar to someone else? Does somebody else already own it? This is something also I think I want to go more in depth on. And the last consideration is, do you have a signed consent? So anytime we get a trademark with somebody's name or a realistic depiction of them in it, we're going to ask for their signed consent to register it as a trademark. We have talked a little bit about minors because, there's high school athletes right now considering NIL rights. There are some states that don't allow minors to enter into contracts or legally binding obligations. So something to consider if you're in one of those states, actually signing a trademark application with our office and also signing that consent to register, your parent or guardian might have to sign on your behalf. Just something to put on your radar. Okay, so the goods or services. What are you using your trademark on? Essentially, when you file a trademark application, you're going to choose what goods or services you provide, and we have essentially classes. So you're one class with your trademark application, and then if you want additional classes of goods or services, there'll be a fee attached. So class 25, clothing, all clothing goods, baseball caps, hats, everything in there. Might be something you'd be interested in if that's what you're going to be putting your trademark on. Class 35 is all our business services, including endorsement or promoting the goods or services of others. Class 41, big entertainment class, so if you're making personal appearances by a sports celebrity or motivational speaking or even live concerts, lots of options. And these are just 3 classes that I've given as examples. There are many more. If you're doing jewelry in class 14 or you're starting a hospital in class 44, I might have lost the thread on that one, but we have lots of classes and you would be paying for each one if you want to register your trademark for those. Is your trademark too similar to someone else's? So we have a test when you apply, and it's to look for if someone else is using the same trademark or a similar trademark used on goods or services that are the same or related to the ones you've identified. So many people can own the same trademark. For example, Delta owns it for airlines and Delta owns it for faucet. These are not the same company, and we don't believe consumers would be confused. But in other cases, when the marks are similar and used on related goods, sneakers versus caps, we think that consumers might be confused. I am going to use a reference that today's college athletes might not know, but in the movie Coming to America, there's a character there who has a fast food restaurant called McDowell's, and he says, "We're not McDonald's, we have golden arcs, not golden arches." And I think that was funny before I became a trademark attorney. And now that is the exact type of source confusion that we try to prevent here. So that's what we're going to be considering when we look at your trademark application. So before you apply, you can go to our website, there it is, www.uspto.gov, and you can click on trademarks and search our database, and you can see what other people own. You can search it and see if what you want to own is on there. And if nobody owns what you're considering, stay on that same webpage, create an account, and you can go ahead and apply for your trademark right then. Just some basics. If you forgot what we talked about today, or if you have more questions, we have the Trademark Basics website right there. We also have it's for 90 minutes every week for 8 weeks in a row, called our Trademarks Bootcamp. It teaches you everything you need to know, and you can ask questions. That is also our NIL one-pager, if you'd like to go there for some background too. So a bit of a note, once you've applied for a trademark application, it is public record, and sometimes there will be scammers coming out of the woodwork to try and get you to give them money. So basically your email is public record in your trademark application. Just know that we will never ask for money or personal information over email, text, or phone. And when we contact you, we will have a .gov in our website or a .gov in our email. So anytime someone might be asking you for money, please go to Trademarks Protect and just double check your rights. So that is it for me and Trademark Basics.
Thank you, Liz. That was such in a nutshell, such valuable information. And I really greatly appreciate you sharing our website, because that's also a source of incredible knowledge, education, and information for our viewers. So we're now at the exciting part of our time together, or the more exciting part, and that is to take some questions from our audience. So I am going to invite both of you to jump in as we view some of the questions. I know we had, the last I checked, over 1,800 people registered for today's program. So I suspect we've got a host of questions. So we'll get those questions coming in and see where we can get started. Let's start with this one, and that is, how should extraterritorial concerns be regulated by a nation or state in order to protect its citizens? That sounds like it may be a deep dive, but let's see if we could hit that one briefly.
So one of the things about all intellectual property law is that it has a transnational component to it in basically every field. One of the things that I tell my students in the introductory lecture is, as soon as patent law became sort of economically significant, we began to see international agreements about it. There's now the trade-related aspects of intellectual property is a massive treaty that's part of the World Trade Organization, treaties that most nations have agreed to, that sort of regulates patent law and copyright and trade secret law on a transnational basis. I expect that you'll begin to see these kinds of agreements with respect to NIL fairly soon. I think the value of the rights is becoming so important. The concerns about AI are not just this country, it's every country. The cases that we're hearing about are not just this country. So I think we are going to see international agreements. And the way the law has been built up in this is nation states often experiment with different approaches, but then eventually they try to converge on a single approach. So you might see in the next few years the United States taking an approach that's more grounded in trademark law, and maybe some European countries thinking it's more like copyright law. And we'll eventually get to, I think, some convergence. You don't have to have convergence, but I think usually you do see convergence, but that will be a process that people, especially people in the legal profession, will participate in and help build the international framework for this area.
Maybe an opportunity for harmonization.
Possibly, but I think there's a value to diversity before you harmonize, that you see different approaches, you see experiments. So I once wrote an article entitled Harmony and Diversity in International Patent Law. And my answers to whether I wanted harmonization or diversity was I want both. I want both because you get the diversity has an experimental value to it. And especially in a new area like this, our states have experimented in it. I think different governments across the world are experimenting in this. We need to see how it pans out.
Liz, I think we've got one for you. And the question is very simply, can I trademark my face?
Yours, Elizabeth?
Well, maybe not mine specifically, but the individual asking the question would like to trademark their face.
Sure. Yes, you can trademark your face. But like I think I've talked about it ad nauseum at this point, it's got to indicate the source of goods or services. But we see that all the time. I mean, the first one that came to my mind is Wendy's. Doesn't she have the face on the signage for the restaurant services? So yes, you can trademark your face. Just think about how you're going to be using it in commerce to sell goods or services.
A follow-up question on that. If your claim to goods and services is I'm on Instagram and I give advice about sports and movies, and that's what I do, and I've got, several followers and I'm building my following. Is that commerce?
Yeah, so let's a couple things there. Number one, you will need to think about what your goods or services are, but informational services or providing advice is a service.
Yeah.
But I should mention that when you file a trademark application, there are a couple things to consider. You might not be using it in commerce, but we allow you to file as long as you have a bona fide intent to use it in commerce. So, and then once you are using it, you have to prove it to us. Or you can file that you're already using it in commerce and have what we call, it's a weird term, but it's called a specimen. And that specimen is going to show that you're actually using it in commerce. For example, a website saying, I'm offering my advice services about these certain things. And you would submit that, and that would have your face on it, or whatever you're choosing to use as your trademark. So I think I answered that, did I?
That's great.
Okay.
Thank you very much.
Liz, because these nuts and bolts are so important to someone successfully filing a trademark application, how long can one remain in that category of intent to use before the office, or they need to really put their money where their mouth is, so to speak, and say, here's my use in commerce?
We do allow, so when you file for an intent to use application, we're gonna go ahead and give you an opportunity, so many months, 3 months or 6 months, to file either your statement of use at that point or an extension. But each time you file an extension, you're going to be paying money. So you cannot hold it indefinitely without actually using it in commerce. So.
We do have an additional question, and I'll open the floor to both of you. And that is, what is the best approach to placing an artist's signature and marks on published and exhibited works? I don't know if this is...
Start with that?
No, I think you should.
Well, I think there's no bar to getting trademark for a signature. And in fact, some famous companies have as their trademark, their signature. So I think it's interesting that a lot of artists, when you're talking about paintings and works of art like that, the market tends to be in the original. Interestingly enough, there's an enormous value and premium for doing an original, even though a computer could, reproduce the artwork brushstroke by brushstroke on the exact same canvas. We call that a fake. Even if it has the artist's signature on it. So the market for artwork has this incredible premium for the original physical good. So I'm not so sure an artist would necessarily need to trademark the signature. And I'm talking about the signature that's down in the corner of the painting, but they certainly could do it if they wanted additional protection. And then I guess if you did a photo of the artwork, not only would you have a copyright claim, but you might also have a trademark claim as well, because it would include the signature.
Yep, certainly, as long as it's shown as the source of works of art, which would be a Class 16 printed good. You got to memorize it.
Okay.
You can, but yes, when I saw a work of art, I was like, oh, we're in the copyright land. But yes, you can certainly be a source of printed works or works of art as well.
Maybe that last question I think that's interesting.
I hesitate to let us jump into the next question because I see, unfortunately, because this is a topic that could go on all afternoon as well as into the spring and summer, and maybe we'll have to have a part 2 of name, image, and likeness. We are at the top of our hour, and we commit to our viewers that we will keep this at an hour. We do have one final special thing occurring today, and I want to turn the program back over to our Director Squires.
Thank you very much, Elizabeth. Liz, Elizabeth, and John, I must say, an absolute home run. And I'd like to invite John to come up. Well, the Academy has its Oscars. Broadway has its Tonys. Recording industry has, of course, the Grammys. But we have at USPTO our a patent and trademark thank you or a patty.
Thank you very much.
Thank you for a great session, John.
Terrific. Yep, let me not drop it and shake your hand too. Thanks a lot.
Thank you.
Thanks.
Appreciate it.
Terrific.
So we want to thank our entire audience for joining us today and to remind you that today's program was recorded and can be found on the USPTO Hour webpage of the uspto.gov web address. Thank you again, and we hope that you'll tune in for many of the upcoming USPTO Hour programs. Thanks so much.